Good morning, everybody, and welcome to week 14 of our 15-week CWS webinar preparation course. This is our next to last class. In fact, it's kind of our official last class because next week is just review. We're going to go through some of the quizzes. We're going to talk about some of the test-taking procedures. I am curious to know when everybody is going to be taking the exam. Those of you that I know there's some of you that won't be taking it again until after the first of the year, or taking the exam until after the first of the year. If that's the case, and you want to do a review right before, if you want to do a live review right before the test, then let us know, right before you take it. Then we can get you involved in one of the other classes. I'm currently teaching this class 2 other times. So I have 2 other classes going on weekly, and we can get you involved in one of those classes if you'd like, and onto a week 15 review. We do plan on doing a live review. If some of you may be waiting to take the exam down in Orlando next year at the National WQA Convention. If that's the case, then be happy to give you we're going to do a live review, get a room down there and meet and have a live review for WQA, people taking the WQA exam at that time. So let me know where you're taking the exam and what I can do to help you. Next week will be a review. We're going to talk a lot about the exam and the preparation and everything, and how to prepare for it. And I would encourage you to listen to Tanya Lubner. There's a recording, an MP3 recording, a phone recording that we have with her. It's posted on the website, and I would encourage you to listen to that before taking the exam as well. It might give you some insight on some of the things to prepare for. But today, let's get started on this. Can you guys chat and let me know whether or not you can hear me okay and whether or not the screen looks all right? Can you guys just give me an indication if somebody could chat and let me know whether or not everything looks okay there? One of you? Good. Okay, perfect. All right, let's see here. First and foremost, what I always like to do, I like to start every presentation off, of course, with a thank you. I definitely appreciate the opportunity to serve you in this way. And it is always my goal, every time I give a presentation, to make sure that the information that I give to you is at least as valuable as the time that you're giving to me. I really do appreciate it. I appreciate that you guys are taking the time to be here every week, and that you're putting forth an effort to get the certification. I think that helps our industry, and that's something that I very much appreciate also. So what we're going to talk about today, there will be quite a bit on today's lesson that you will have on the test. Now, most of it when it comes to the Code of Ethics, hopefully you already have down. I mean, because a lot of the Code of Ethics stuff is just a right and wrong type thing. But there are going to be some things that you're going to want to study. You have the Legal Considerations Handbook. What I'm going to go through in this class today is just an overview of that handbook. I really recommend that you read that book. It's pretty short, particularly the sample lessons at the end. Okay, as they go through and they have the sample lessons, I recommend that you read the sample problems and identify some of the problems and some of the things they have there and that you'll ace this part of the test if you do that. But I'll try and point out some of the things that you're going to want to pay special attention to. But most importantly, I recommend that you read this Legal Considerations Handbook. The other thing I want to mention here is that I'm not a lawyer. I don't even play one on TV. I don't even pretend to be one. And what that means is that the stuff that I'm going to go through here is stuff that I took directly out of that Legal Considerations Handbook. If you want more details on any of it, I really recommend that you talk to your attorney or talk to a business attorney. I am not qualified to give legal advice at all, so And frankly, neither does WQA. This is just a book that they have. It's an overview of the things that you should take into consideration. So we are going to talk about some legal considerations, though. Laws controlling consumer sales, warranties, laws controlling consumer credit, consumer leases, product liability, consumer product safety laws, antitrust laws, franchise and business opportunities, sales representative laws, labor laws, and then some miscellaneous laws. And then we're going to talk about the code of ethics. Just to give you a heads up, you're not going to really need to know, you're not going to need to memorize law code here. This is, I think it's what they're looking for in this lesson is just for you to have an understanding of some of the basics, some of the things that you're allowed to do and not allowed to do. So some basic business practices, but you're not going to need to know, which act was passed when or anything like that. Okay, laws controlling consumer sales. This includes honesty in business, deceptive trade practices, and consumer fraud laws. Honest advertising, it means complete and accurate advertising. It covers door-to-door sales and specifically the cooling off period, and mail fraud. State consumer information laws for water quality improvement products. Deceptive trade practices and consumer fraud laws. These allow the state attorney general or the Federal Trade Commission to intervene if there's an issue. Consumer fraud is a deceptive act to get a consumer to make a purchase. So if you're doing anything deceptive to try and get somebody to buy something, that's consumer fraud. And that's going to include any false or misleading advertisement. It can be made through words or conduct. And so that's important, is that it doesn't necessarily have to be in writing. It can be just through your words or through your actions. False or misleading words or concealment of facts would fall under consumer fraud laws. There are 3 categories of deceptive trade practice laws. Deceptive claims about one's own products or services. That means that you can't claim that your product is going to do something it's not going to do, or not going to do something it is going to do. This misleads people regardless of anything that misleads people regardless of the intent. Okay, regardless of the intent. Dropped somebody, so I'm hoping that the internet here is going through here. So it doesn't matter whether you intended to deceive them or not, even if it was accidental. And just as an example, not that I think that this is one that would cause somebody to necessarily really throw a loop, but I had a client in Ohio, and they were talking about their water softener, and they were talking about it being upflow brining or countercurrent regeneration. And this was what the salesperson was talking about. He was selling it based on this feature. Come to find out, that wasn't in fact how they were setting the valve up at all. It was downflow. They were setting it up for downflow. So that was a deceptive trade practice. He didn't mean to. It was an accident. But that would have fallen under under these laws. So it's very important to know what you're selling, know what the features are, know what the benefits are, mostly the features, and make sure that you're presenting your product accurately. They're written to protect the public regardless of education. So I know it's not your customers. Your customers are all brilliant. I realize that, but some people have customers that aren't so brilliant. And these laws are designed to protect everybody, regardless, all the consumers, regardless of how educated they are or how, not educated they are. Deceptive sales practices. You can't say something is certified to do something it's not going to do. You can't cause confusion or misunderstanding. And that becomes relevant, when you're talking about all the, you start throwing out all kinds of terms, countercurrent regeneration and upflow brining and salt efficiencies and all these terms that the customers may not have a clue about, but they don't understand. It causes confusion. If you're making the customer confused, that actually could fall under these deceptive, especially if it's something that happens commonly. But that technically could fall under these rules. So deceptive claims about the products or services of others. You're not allowed to say something wrong or misleading about somebody else's product or service either. Sweeping absolute statements that are not true in all circumstances should not be made, ever. Never, ever, ever, ever make a sweeping, I mean absolutely under zero circumstances should you ever make an absolute statement that is not true in every last single solitary instance, sort of like what I'm doing right now. Those are sweeping absolute statements. Words commonly used in context substantially different from their use in particular promotional materials should not only be used accurately, but should be qualified or further defined within such materials to avoid confusion and possible misrepresentation. For example, pure water or purifier. Okay, that you should clarify what that means. Make sure that when you're talking about a water purifier, it's impossible to have pure water outside of a laboratory setting. So when you're talking about pure water, you got to clarify that. Statements about the performance attributes or benefits claimed for a product should be limited to proven facts, particularly when the attributes or benefits claimed are not readily verifiable by customers or by your consumers. In these cases, the claimed attributes or benefits should be described and qualified in more complete and comprehensive terms. So make sure that that you back up your facts. If you're spouting statistics, make sure that you can you have a place to back those up, that you can direct them to where they need to go. Laws controlling consumer sales. You cannot use bait advertising. What that means is you say that, hey, come on in and buy this $200 water softener, and then when they get in there, oh, sorry, we're all out of those, but we have this $1,200 water softener that you can buy. Not allowed to do that. That's bait advertising. Warranty or guarantee, these are important. The laws controlling consumer sales cover the warranties or guarantees, and you got to make sure that you're very careful on how you use these terms and what you're saying. We're going to talk about warranties here in a minute, but and how you word those. We're going to talk about what types of warranties there are and what those mean. So we'll talk about those more in a second. Buy one, get one free. If you're doing a buy one, get one free, then you cannot raise the price of the first one up to twice as much and then say the second one's free. It has to be, if it's truly a buy one, get one free, then it has to be the first one's at a regular price and then the second one is free. If you're going to do a $21.99 now $12.99 type thing, then the price, the original price has to have at some time realistically been $21.99. You can't just say that it was that and now it's $12.99. So it has to have at some point actually been $21.99. Mail fraud, this is a federal offense. Anything that you send through the mail cannot be deceptive at all. I knew a guy in college one time that committed mail fraud. He was at this bar, but I don't think it's the same kind of mail fraud actually. So I think the kind of mail fraud that they're talking about here is the paper stuff that comes in the mailbox through the postal service. So actually, if you break the rules on this, they can actually take all your mail during the investigation, which would stink. Unless they could somehow only take your bills and leave you all the good stuff, but they won't. They don't really distinguish that. They take it all. Okay, warranties. There are a couple different kinds of warranties, and this you will want to become familiar with and know. Express warranties. This covers your written warranties and oral statements. So express warranties are either written warranties or oral statements. And then you have your implied warranties, and that covers the implied warranty of merchantability and implied warranty of fitness for a particular purpose. So warranties of title and against infringement. Any express or implied warranty is a promise which may be legally enforced if your product does not live up to legitimate expectations covered by the warranty. If there's a breach of warranty, the damages may be awarded to the buyer. The warranties must be available for the customer to read before the sale, especially on door-to-door sales. Okay, so if you're doing any in-home sales or selling, you actually, by law, have to have a copy of that warranty available for them to read before they make a purchase. You should have a copy of that somewhere. Express warranties, like I said, can be written or oral. The written warranties are subject to Federal Trade Commission regulations via the Magnuson-Moss Act. Does not require written warranties to be issued, but if they are issued, then rules have to be followed. If it's a manufacturer's warranty, the manufacturer is responsible for it. There are full or limited warranties. A full warranty must include a statement of duration. Cannot charge for anything, including service. If it's a full warranty, you cannot charge for anything, including service. A limited warranty, and this is probably the most common out there, is when there are exceptions. So you can say, 10-year warranty, 10-year limited warranty is going to be, 10 years on the tanks and resin and all that, but maybe not on the computer component. A warranty must include the identity of the person to whom the warranty is extended, a clear description of the product or components covered or excluded, a statement of what the warrantor will do in the event of a defect, a step-by-step explanation of what the consumer should do to obtain performance of the warranty obligation, the duration of the warranty and the day it commences, availability of any informal dispute settlement mechanism, any limitation on the duration of implied warranties, any exclusions or limitations of relief to which a consumer is entitled under the warranty. And this has to be on every warranty out there. The statement, this warranty gives you specific legal rights, and you may also have other rights which vary from state to state. By law, that has to be included somewhere on the warranty. A warranty you cannot base the warranty on use of a certain product unless the product is free. So you can't say this warranty is only good if you buy salt from us, unless you're providing that salt. You cannot void the warranty if someone else provides service unless the service would be free. Spoken warranties are any statement whether or not it says warranty or guarantee. So I promise this will work. That's a spoken warranty, and warranties, opinions don't create a warranty. So is this going to work for my family? I really believe this is going to do really well for you. I really think that this is going to be the right option. That is different from saying absolutely, I guarantee, or I promise, or I assure you this will work. Okay, those absolute words, the I promise, I guarantee, I assure you, those create a warranty. Saying I really believe that it will do the job does not create a warranty. Spoken warranties are governed by the Uniform Commercial Code, the UCC. Now, implied warranties were created by the UCC in every sale of goods transaction, whether the dealer or manufacturer makes any statement or not. Implied warranty of merchantability says a product will do what it claims to do. An iron filter will filter iron. A water softener will soften the water. A lawnmower will cut the grass. Okay, that's an implied warranty. Disclaimers can be put on products with implied warranty, so you can say proper water conditions. Implied warranties of fitness for a particular purpose assumes the consumer is trusting the merchant to provide the proper equipment for the job. Warranty of title and warranty against infringement basically says the product is free of any securities or lien. These are the laws controlling consumer credit. There's truth in lending laws. This is the law that informs consumers of the true cost of their credit. Financing charges have to be clearly identified. Number of payments, amount of payments, and when the payments are due have to be shown. The credit practices rule prevents contractual clauses that require the consumer to forfeit certain debt rights. Prevents pyramiding late fees, so you can't charge late fees on top of late fees. Provides rules for, you can't charge late fees on late fees. This provides rules for cosigners. The Equal Credit Opportunity Act says you can't decide to provide or not to provide credit based on race, color, religion, national origin, sex, age, or the fact that an applicant's income is solely from a public assistance program. It is the law that allows a person to know why they're not approved. That's the Equal Credit Opportunity Act. The Preservation of Consumer Claims and Defenses Law ties a creditor to the merchant in terms of liability. That means that if somebody is if there's deception going on, it used to be that somebody could buy something and they'd go back and sue the person that sold it to them, and the creditor would say, would still make them pay the money, even if they got frauded. Then the person couldn't, they would still owe the creditor the money because the creditor still owned it. Now that they're tied together, so if the creditor loans money for a fraudulent product or service, then that creditor is partially responsible too. The merchant has to tell a consumer which credit agency they use. The retail installment sales or the usury laws regulates the maximum amount that can be charged for a finance charge or late fee, and these will vary from state to state. The debt collection practices are governed by state law, not federal law, but in general, you cannot use abusive or harassing collection practices. The Federal Consumer Leasing Act of 1976 applies to leases longer than 4 months for $25,000 or less. Product liability, the injured person must prove the personal or property injury came from negligence. These laws are designed to hold the merchants liable for injury or damage if the merchant is negligent. And these are going to vary from state to state as well. Consumer Product Safety Act, these are regulated by the Consumer Product Safety Commission, the CPSC. They make sure products are safe. And then antitrust laws, these cannot interfere with free competition. They can't make any agreements regardless of price with a competitor. That means that regarding price with a competitor. So you can't go to one of your competitors and say, hey, I'll tell you what, I won't sell my water softeners under $1,000 if you don't sell yours under $1,000. That's illegal. You cannot do that. Relationships with suppliers, these cover territorial restrictions. The division of customers, the supplier can't tell a dealer to only sell to residential. They're just a supplier. They're not allowed to tell you what you can and can't do there. Exclusive dealing. Supplier can't tell a dealer not to sell other equipment. Now, there are differences between independent dealers and franchises. Franchise agreements, we'll talk about those in a second, do have some different laws regarding them. You do in a franchise contract, the supplier or the manufacturer or the owner of the franchise, they can regulate. There are some restrictions there. We'll talk about those in a second. Requirement contracts requires a dealer to purchase all of one particular type of product. Requires a dealer to purchase all of one particular type of product from the supplier. You can do that. That's legal. Resale price maintenance. You cannot sell a minimum price, or you can't set a minimum price. The manufacturer can't set a minimum price, but it can give a suggested retail price. Tying arrangements, you can't force a dealer to buy a product they don't want in order to get one they do. So you can't tie the products together. So you can't say in order to buy water softeners from us, you have to buy a reverse osmosis at the same time. You cannot do that. Discriminatory pricing, a supplier has to offer the same prices to every dealer. Now, they are allowed to do some tiered based on, they can set it so based on levels. So you order this much, then you get this price. You order this much, you get this price. So they can do that, but those opportunities have to be the same for everybody. Relationships with other dealers, you can't make deals with your competition. Relationship with the consumer or ultimate user, you can't require customers to buy from you for more than a year. And unfair methods of competition, this covers the loopholes in the other laws. Okay, so franchise and business opportunities. A franchise law will differ from state to state, but in general, most of them will use the California definition, which says that a franchise is a contract or agreement, either express or implied, whether oral or written, between two or more persons, by which the franchisee is granted the right to engage in the business of offering, selling, or distributing goods or services under a marketing plan or system prescribed in substantial part by a franchisor, and the operator of the franchisee's business pursuant to such plan or system is substantially associated with the franchisor's trademark, service mark, trade name, logotype, advertising, or other commercial symbol designating the franchisor or its affiliates, and the franchisee is required to pay directly or indirectly a franchise fee, although not all states require a fee to create a franchise relationship. Sales representative laws, these do also vary from state to state, and they're designed to protect the sales representatives, especially those earning straight commission and independent contractors. So these are the laws that cover that. Independent contractors are still considered employees. There are laws regarding them, and they can still come back, and just because you're paying somebody as an independent contractor does not mean that they cannot that you're not still held liable for treating them fairly. They can impose stiff penalties on unpaid commissions and unwarranted termination. Labor laws are laws that protect labor forces. I didn't really feel like typing them all out or reading them all, so I just scanned a copy of the book, which is right here. And they're in there if you want to know what all those are. They're in the book. So, okay. The WQA Code of Ethics. Now, these are important not only for the test. You will see these on an exam somewhere again, but this is actually one of the reasons I really like the certification. When somebody has a certification, they are part of the certification is that they are agreeing to abide by all of these code of ethics, that they're agreeing to do to all of them. Okay, so I think that these are really important, and I think that it is probably as much as the education as important as any other part of your certification. I think that this is one of the things that really helps grow our industry and helps the reputation of our industry. So I'm going to go through each of these and read them. You should all be aware of them. Somebody who is WQA certified and follows the Code of Ethics says that they will conduct themselves as informed, law-abiding citizens dedicated to ethical business practices. They will be informed of and adhere to all laws, statute, ordinances, codes, and regulations applicable to the industry, including those dealing with restraint of trade, consumer protection, truth in advertising, truth in lending, intellectual property protection, selling, registration, sanitation, and effluent disposal. Build their businesses on the merits of their products, services, and abilities. Accurately represent credentials, training, experience, and abilities of all employees and agents. Serve their customers competently and honestly. Ensure that their products or services are properly applied or installed when they are responsible for such application or installation. Respond in a timely manner to customer complaints. Provide for the availability of timely and complete installation and service for the products. Inform customers of the general maintenance, service requirements, and related costs. Pursue the advancement of knowledge and skills utilized in the water quality improvement industry. Adhere to and promote the Code of Ethics. It says that you're going to follow certain marketing guidelines, which says that all claims should be based in fact. And this is really important. I hear so many salespeople out there that will make claims that they heard or misinterpreted or just make stuff up. All the claims that you make should be based in fact. You should accurately represent the water source, treatment process, and benefits. Use accurate literature and labeling, and don't trash talk city water or your competitors. Stay away from sweeping, absolute statements. Be careful about using the word pure or words like healthy, purification, safe, contaminants, etc. Every statement should be true in its entirety. Don't omit facts in order to mislead or misrepresent. be able to explain the process and scope of all the water tests done, know the rules on using the words warranty and guarantee, get permission to use an endorsement, and lastly, before we end this today, read the practice scenarios. Like I said, read the practice scenarios. Next week we will go through and study. Please let me know when you plan on taking this exam and where. Communicate with me. And other than that, that's a short class today. It's done. Sample tests are online. Feel free to go on and take them and see how you do. Other than that, we will talk to you guys next week. Thanks, everybody.